Let me share yesterday's. I was up to I really it was a very uh, him- doctor was much worried. He was HOD to a major government hospital in Mumbai, and he wanted me to accompany. Normally, I don't go to MMC or any medical consult because this is the place where doctor need to speak. But just because of his worry, I attended the court with him. This was a case of 2017 where patient came with abdominal discomfort with a clear indication of gastritis. Doctor has done all investigation, proper investigation, including endoscopy. And on the basis of pathological and other report, given a treatment of PPI to the patient. 2018 January, last patient came to this doctor. Thereafter, never turned up. And then he sent a complaint to MMC saying that the treatment given by gastroenterologist has caused me sexual dysfunction, erectile dysfunction, which spoiled my life. Simple complaint of sexual dysfunction was done to MMC on without no basis, no investigation, no evidence, nothing, just a letter that treatment given by XYZ doctors caused by sexual dysfunction or ED and been taken by MMC. Inquiry initiated 2018 and today 2022, almost 4 years when this doctor got a letter. In between, he replied in 2018 when complaint was reached to us, and we thought probably to have settled, but 2022. I was utter shocked when I attended this court. Lots of inquiry done for the purpose of a treatment. When I intervened and spoke to the authority that complaint is of ED, not of any medical negligence or any other unethical practice. And secondly, patient has never ever came back for the follow-up. It is difficult to understand that the complaint lodged by the complainant has got some value or not. And secondly, majority of side effects are irreversible. Sorry, reversible. When it is reversible, the moment patient would have stopped the medicine, even if at all side effect been shown, patient would have got normalization. So it is difficult to ascertain that. And even doctor, when inquired about that, do you inform every patient about the side effect of the drug? It was really a tricky question because it's not possible for every single doctor to give complete detail about side effect of every drug, knowing that there is a constraint of time, there is a constraint of lot of things. Doctor said I majorly do the same in a major patient where major side effects are shown, but I do write on a paper or inform if at all any adverse reaction found, please do come immediately or follow up within a stipulated period. I know the result is going to come in his favor, but why I'm sharing all this? Simply because in medical counsel, the action against the doctor can be initiated by any frivolous complaint and also not directly complain to MMC, but or any medical counsel rather, but just tweeting to various authorities can lead to complaint. But in my experience, majority, rather 90%, I can say more than 90% goes in favor of a doctor because such a complaints are a frivolous case. So today I'm going to deal with laws of medical counsel, laws of ethics. What are the ground where complaint can sustain if properly been framed? What are the ground needed to file a complaint and how you can defend your doctor only on a complaint and a ground of complaint? Because 90% time I have observed that complaint is more towards the medical negligence, more towards other things, whereas the ethics and ethics regulation 2002 says that matter of all short of ethical violation should come to them. Ethical violation domain has been extended because of one case, the power has been given to the committee to take other cases. Medical negligence cases are also been admitted and been heard in medical council. Medical council has got a power to give three punishment. One is either they will give a warning, please take care for next time, don't repeat such a mistake. Second punishment is going to be suspension of a medical registration for a few period. It could be 1 day, it could be 3 days, it could be 7 days, it could be a month or two. Or third punishment, removal of name, that is permanent deletion from the register It is like a professional death penalty, which is very rare because it happens only in conviction in moral turpitude cases, rape cases, other things. Otherwise, such a harsh action is not being taken. Today, we are dealing with Regulation 2002 because that still exists in this country. But after after NMC has been formed, MCI Act has been repealed. It is a duty of NMC to form a new regulation and make a part of the law. In absence of a new regulation, old regulation still working. New regulation draft has already been put in a public domain by National Medical Council. National Medical Council has published that also, but notified or notification not be done because objection raised by various domain are being considered. Probably redrafting would be the possible thing, and then we will get that law. Once that law comes, that is 2022 regulation. 2002 regulation will be repealed. We are awaiting for that. Once it will come, definitely I'm going to take a session for that also. The draft is already available. From 3 punishment, they have changed it to 11 punishment now. The new draft has talked about 11 types of punishment in medical council's action. There are a label of violation defined 3 level where punishment is starting from warning to 3 months to 1 year to 3 year, and including the first time ever new draft has said about compensation, which was not with the power of a medical council, but first time they are taking a power to compensate also like a consumer court, and that is going to be the new domain. And lots of things had been brought under the draft. Since draft has not been notified, draft has not seen the color of a law today. There is that not fair on my part to deal with that draft at this stage. Let get notified. Let actually become the law, and we will deal with that draft. Since 2002 regulation are still existing, in today's session, I am going to deal with all this law which is existing in this country. So please understand what types of the ethics have been spoken in a law, how the cases are being filed against the doctor, and how can defend a doctor in a medical court. Again, let me repeat you the important aspect of defending your doctor or your own self or any of your client in medical counsel. The law is exactly similar to your consumer fora. Because in consumer fora, authorized representative can appear. Authorized representative means not necessarily be a lawyer. If you are a lawyer, no problem. Naturally, advocates are allowed to appear in every court, quasi judicial or judicial bodies. But in quasi judicial bodies, where law has allowed authorized representative to appear, in that domain, 95% plus cases are of medical negligence. So your client could be a doctor or a patient who has filed a case in medical counsel or a consumer court. Around criminal court, hardly 5% cases goes. In both the domain, being authorized representative, you are allowed without having a LLB degree or a bar council registration. So take advantage of this because this is the time where you can promote yourself in good way by appearing for your client, either for the patient or for the doctor in medical counsel, also in consumer fora. So in medical counsel, you are absolutely allowed to appear, defend, argue the matter, the procedure, what we have learned in a consumer fora. We are going to have the procedure here also. See how the complaint comes, reply need to be done, evidences to be put, argument to be done, and if at all the procedure says you can defend a doctor. Preliminary inquiry is the new domain in medical counsels cases. Preliminary inquiry means if any frivolous case comes, it is on a body to decide that they should frame a charge or not a frame a charge. Like a private complaint done in any of the court under 156(3), where first preliminary inquiry is done, then process is issued. In the same manner, in a medical counsel also, first preliminary inquiry done. If at all they found that this complaint is frivolous, they can throw it out. Depend upon the council. It is not that every council follows the same. Every state council has got their own strategies to take a case, but by and large, preliminary inquiry also give advantage for dismissing the complaint. If at all committee founds that there is a important aspect of taking the case ahead. They can issue a charge, they can frame a charge, and then process start. But process is simple: complaint, written reply to the complaint, evidences by both the party, if needed, cross-examination and questionnaires, and then written argument and argument in the court. The procedure is going to be same. So let us understand the law in nutshell. I'll give a brief idea about the regulation 2002, how and what way this medical council deals with this law. This was a regulation made in 2002, 6th April 2022. Draft has already been brought for the public for their objection, which is available on internet. That draft has not been yet notified. Any moment it can be notified. At that time, this particular regulation will be repealed, because this is published under Section 4 of a gadget under the MCI power. So now MCI is not there. They have used MCI is not there. Power is vested on NMC. So MCI is repealed, so NMC will come, and like same the power confirmed under 20A in NMC, it has been again given a power. They can make a regulation, and we need to wait for the regulation. So it has got few important aspects which we need to understand. Code of medical ethics, naturally, they talk everything in detail. They talk about a declaration to be given by the doctor. They have enumerated the duties and responsibility of physician in general. Character of physician, naturally they've spoken about that. Physician should hold dignity of honor of the profession. One important aspect which you need to understand: a physician should be an upright man, instructed art by healing. He should keep pure character. He should moderate, sober his duties without anxiety, profession action. Point 1. A person obtaining qualification in any other system of medicine is not allowed to practice modern system of practice in any form. They have mentioned that in that, but does not block any doctor in that, because naturally every state has got their own laws. Always remember, my friend, since you are being from the law background and since medical law student and going to be medical legal consultant, one important aspect you always keep in mind: act formed by the parliament is supreme. It cannot be challenged unless it can be overruled by parliament itself or amended by parliament itself. So act is supreme. Even Honorable Supreme Court, if at all there is ultra virus section, can only deal with that. But Supreme Court also cannot go against case of ART Act and MTP Act defined unmarried girl for the purpose of a pregnancy. That was the broader definition given by Honorable Supreme Court of a parliament mentioning on the act, but they have not repealed the act altogether. So act is supreme, always remember. Below the act is the rules and regulation. So rules and regulation is the third part, are is the process for making a process. Rules and regulation is made to execute the act. So regulation is always on PD side. Now, why I am sharing this? Because this word was mentioned in a rule. The person obtaining qualification in another system of medicine not allowed to practice modern medicine of system. Now, this is the rule. This is the regulation. Now, let me give example. Maharashtra Medical Practitioner Act 1965 have been amended by the parliament, and they have added in section 25, 4 and 5 that graduate and postgraduate from Ayush department or CCIM or from their pathy are allowed to do modern medicine of practice. Now that is mentioned in, of course, act is going to prevail. So this can be easily changed. Why I'm sharing? So if tomorrow opponent comes with this particular section of regulation and you are defending any Ayurvedic doctor in a state where they are allowed to do modern medicine of practice, you can give this defense to the body that it is mentioned in the act and this is mentioned in regulation. So regulation is always below than the act. So that's the reason I have thought of enlightening you for the purpose of this same.